So, friends, with Special Counsel Jack Smith moving to dismiss both of Donald Trump's federal criminal cases, it sort of feels like the rule of law has died. But it might be more accurate to say that the rule of law has been put into a Trump-induced coma. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. Well, friends, November 25th, 2024 feels like yet another dark day in a long line of dark days recently, because after lengthy criminal investigations and after multiple grand juries indicted Donald Trump for his crimes against the people of the United States, Special Counsel Jack Smith just filed motions to dismiss both of Donald Trump's federal criminal prosecutions. Now, we'll start with the new reporting, and then we'll talk about the two most important words in these motions to dismiss and why they may be the only two words that provide any glimmer of hope that Donald Trump may someday be held accountable for his crimes. But let's start with the new reporting. This from the New York Times. Headline: Special Counsel moves to dismiss 2 felony cases against Trump. The Special Counsel bows to Justice Department policy against prosecuting sitting presidents. The Special Counsel, Jack Smith, asked a federal judge in Washington on Monday to dismiss the indictment charging Trump with plotting to subvert the 2020 election, bowing to a Justice Department policy that says it's unconstitutional to pursue prosecutions against sitting criminal presidents. Minutes after the filing in Washington, Smith made a similar filing to an appeals court in Atlanta, ending his attempts to reverse the dismissal of the other federal case against Trump. In that case, Trump stood accused of illegally holding on to classified documents after he left office. Prosecutors said they intend to pursue Mr. Trump's 2 co-defendants in the documents case. The moves by Smith were an acknowledgement that after an intensive investigation and 2 years of courtroom drama, prosecutors will not be able to hold Mr. Trump accountable for his efforts to undo the results of the 2020 presidential election or for accusations that he illegally kept scores of classified documents at his Florida home after he left office and obstructed justice by violating a grand jury subpoena for the return of those documents and violating our nation's espionage laws because those documents contained what's called national defense information. All my editorial edition. The article continues. In both of their filings, prosecutors cited a Justice Department policy that sitting criminal presidents may not be prosecuted. That policy, Smith wrote to Judge Tanya Chutkan, who is handling the election case in federal district court in Washington, is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the government, the prosecution, stands fully behind. And friends, here is the only glimmer of hope, the only light, however faint, amidst all this darkness. But as he, Jack Smith, sought dismissal of the cases before Trump is inaugurated, Smith did not definitively close the door on eventually prosecuting him. In both cases, Smith's requests were for dismissals without prejudice, leaving open the possibility that the charges might be refiled after Trump leaves office for the second time. Now, friends, we're not going to read the whole 6-page motion to dismiss because I think the New York Times article does a pretty good job of covering the legal landscape, but I do want to circle back to the two most important words in Jack Smith's motion to dismiss. The government, meaning the prosecution, moves for dismissal without prejudice. And then near the end of the motion, Jack Smith goes on to explain, immunity from prosecution for a sitting president would not preclude such prosecution once the president's term is over or he is otherwise removed from office by resignation or impeachment. Okay, friends, let's unpack that. When cases are dismissed, there are some magic words in the law. A judge can dismiss a case either with prejudice or without prejudice. What does that mean? Well, if a judge dismisses a case with prejudice, it means that case can never be rebrought, can never be re-indicted, can never be prosecuted in the future. It doesn't happen all that often, but when a judge dismisses a case with prejudice, it is generally because there has been some serious misconduct by the prosecution in the way the case was investigated, indicted, or in the run-up to trial. And if you prohibit a prosecutor from rebringing that case in the future, you are hopefully deterring future misconduct by government officials, by prosecutors. But the overwhelming majority of cases that are dismissed, criminal cases, are dismissed without prejudice. That means, under the right circumstances, that case can be rebrought, re-indicted, and it can be prosecuted in the future. So Jack Smith has asked Judge Chutkan and the appellate court, which presently has the classified documents case that's being prosecuted down in Florida, asked the judges to dismiss it without prejudice, meaning it can be rebrought in the future if we once again have a law-abiding administration, a law-enforcing attorney general, and prosecutors who want to, albeit very belatedly, try to hold Donald Trump accountable for his crimes against the American people. Dismissed without prejudice. And because Donald Trump's lawyers did not oppose this motion to dismiss without prejudice, it will certainly be dismissed without prejudice. That gives us that slight glimmer of hope that maybe these cases can be rebrought against Donald Trump once he leaves office. However, he may end up leaving office. But there's one other catch, and there's always a catch when you're trying to hold Donald Trump accountable for his crimes, isn't there? One other catch. It's this thing called the statute of limitations. What is that? Bear with me. This is going to be a little bit of a Team Justice Law School class, but we're going to move through it quickly. The statute of limitations basically gives prosecutors a deadline, a time frame in which they must bring a prosecution. Most crimes in the federal law have a 5-year statute of limitations, so you have to prosecute the person within 5 years of that person committing the crime, or it is timed out. It expires. It's prohibited if the statute of limitations runs out. Here is the challenge. If Jack Smith dismisses the case, if the judge grants the motion to dismiss, which Judge Chutkan certainly will, well, if Donald Trump is in office another 4 years, it will be well beyond the statute of limitations for the crimes he committed, the classified documents crimes, the attempt to steal the 2020 election, the Capitol attack, all of it will be well beyond 5 years. So what does that mean? It means that if prosecutors in the future try to re-indict, rebring the cases, Donald Trump's lawyers will march into court and say, they're out of luck. Statute of limitations has expired. I can't be prosecuted. I'm home free. I never get held accountable for my crimes. Well, here is the argument that prosecutors in the future will make if, and I hope when, they rebring and re-indict these cases. They'll say, Judge, the law, the Constitution, as interpreted by the Department of Justice Office of Legal Counsel, makes it unconstitutional to prosecute a sitting criminal president. But we can prosecute him once he leaves office. Therefore, the statute of limitations pauses. It stops. It is stayed during that period of time Donald Trump is president. Therefore, our time to prosecute him has not run out. I think that is a good argument. It's a straight-faced argument. But can I give you the devil's advocate reply to that argument? Here it is. Donald Trump's lawyers will say, wait a minute. There is no law, federal law. There is no precedent, no appellate court has ever ruled, including the Supreme Court, and there is no constitutional provision that says a sitting criminal president can't be prosecuted. It's not a law. It's just DOJ policy, Office of Legal Counsel opinion. That's all it is. Therefore, because it's not a law, the statute of limitations continued to run through Donald Trump's presidency, and he can't be prosecuted. That, I can promise you, is what Donald Trump's lawyers will argue. And friends, you've heard me say it before. I'm not a betting man. I'm not a high roller. $1 is my betting limit. I don't know where I would place my $1 bet on how judges would rule on that argument, that statute of limitations argument, whether Donald Trump has timed out of being prosecuted because the statute of limitations continued to run through his presidency because there was no law saying we couldn't prosecute him, versus the argument that, well, DOJ has interpreted the Constitution as prohibiting us from prosecuting a sitting criminal president, and that's why the statute of limitations should have stopped during his presidency, and we should still be able to prosecute him when he leaves. I don't know how judges would come down on that. I would sure hope they would come down in favor of finding a lawful way to hold accountable a criminal president for trying to steal a presidential election and successfully stealing and unlawfully retaining some of our nation's most closely guarded national security secrets. I hope courts would rule in favor of allowing a prosecution to proceed and letting the jury make the decision about whether Donald Trump is guilty of those crimes or not. And you know why I hope judges rule that way? Because justice matters. It's a dark day, friends, but I believe the light will come again. Please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.